get going.
Let's make sure I am recording to the cloud. I always have anxiety, like I'm gonna forget to push record.
All right, and I'm having some light issues, but hopefully as the sun moves here in just a second, it'll take care of that. But it's probably better for everyone, see my face clearly anyway. All right, well, good evening, everyone. Thank you so much for being here. We're gonna get going tonight. We have a couple of folks who have some commitments for work and family. So we have a couple of steering committee members who won't be here tonight, but they'll be following up with the recording and following up with any questions that they may have. So just so you know, we will be about 4 steering committee members light tonight. So just wanted you to know that. We're gonna jump right in. I'm gonna go over the agenda and then get us going. And as always, we'll finish up the evening with just kind of next steps and some direction to keep us moving forward. So I appreciate your patience and following the communication trail over the last few weeks while I was out of the country. Thank you for that. We were able to secure what you asked for in terms of additional education. So excited tonight to have experts who will be here in a very unbiased way to talk about the easement and then in food and security as well. A couple of housekeeping notes and some just updates for you. We've got one steering committee member who has transitioned off of the committee. That's Fred Glick. Fred Glick was nominated by the Clayton RNO to serve on this steering committee, but he reached out and informed that he has he's now serving on the Denver Planning Board. And while there are planning board members who occasionally serve on project committees, he opted to withdraw just to, he just wanted to be transparent and keep his time good and all those good things. And so just want to say thank you to him for his service up until this point. And so Clayton RNO has nominated Muhammad Khan to take his place. Muhammad has been following this process all along. He's just waved. Muhammad, welcome. Thank you for being here and thank you for stepping in and thank you for shadowing this process and staying, and getting caught up to speed. We appreciate that. The updated community navigators voice report has been updated with the additional engagement focus for the Latino community. 15 additional community members were engaged through 2 additional community talks held in both Spanish and English. The updated report there's a link to the updated report. I'll make sure you guys get that via email and then also put it in the shared drive so you have that information. The Zoom so we're changing the format tonight and moving forward to use the active speaker view. And so in the Zoom webinar format, it's limited for attendees to see other attendees. And so now with the active speaker, whoever's speaking, folks will be able to see that person and engage with them. So if you notice that, we made that adjustment. And then also it's helpful to just acknowledge folks. And I just want to take a moment to see if we have any of our elected officials are with us tonight. Just want to say thank you for being here and take a moment to recognize them. And so I'm not going to call out any names or anything, but just wanted to just take a quick moment to say thank you for your service and thank you for being here to support the steering committee as they do this work. On August 3rd, so this steering committee definitely marked this down, is the next community workshop. And that is from August 3rd from 6 to 7:15. And not only are you invited to be there, there's a request for you to be involved to kind of help facilitate some of the breakouts, and just volunteer to facilitate the dialogue. There's questions or prompts for the breakout rooms. Each room will have about 10 community members in them. You'll be paired with a city staff who will do the note taking and use a Miro board for screen share. So if you're willing to help out or you want to participate in that process, just shoot an email and copy Courtney by Thursday so everyone can coordinate. But it's another great opportunity to hear directly from members from the community, and just an additional way for you to engage. So that is on August 3rd from 6 to 7:15. And if you're interested in participating from a facilitation standpoint, just reach out to Courtney. But otherwise, you're invited to attend, and I suggest that you attend and hear what folks have to say from the community. So for tonight, we'll have two presentations. Public comment has been moved to the end. So that way, as folks are with us and listening, they can hear, everything that's happened in the meeting. And if that kind of shifts or sparks something different for their comments, they have the opportunity for that to happen by hearing and participating in the entire meeting. So we will finish the meeting with our public comment. And then the last act of the evening will be just wrapping up and concluding with next steps. So those are the brief announcements. As always, if you have a question, just shoot me an email, and we'll make sure you get the information that you need. So without those, are there any questions or anything on those updates really quick before we move forward? Okay. I don't see any hands up. I've got the two computer screen thing going today. I don't see any hands up. So we will jump right in. So you guys have, I'm really excited to have Larry, and I hope I don't mess up your last name, Larry, but it's Larry Keeter. Larry Keeter with us to talk with us tonight about conservation easements. And as I mentioned before, this isn't an evaluation of the current easement of the Park Hill Golf Course, but rather easement education. Larry has made it, definitely read over the Park Hill easement. So that way, if there's terminology or specific questions where we need, understanding, those kinds of questions can be answered. But again, he's not going to be giving us a decision or something like that. So again, this per your request, this is some education. You've got his bio. Hopefully you've had a chance to review that and read it. And Larry, I just want to say thank you for answering the call and being with us tonight. I know that you just got back from being out of town. So being with us tonight, we really, really appreciate it. And so we're going to turn the floor over to Larry. And then after that, we'll have some time for some Q&A. And then we'll move into our next speaker. Larry, the floor is yours, sir.
Well, thank you, Dr. Ross. So what I was asked to do is just talk about conservation easements as a general topic to give you kind of some foundation and background for this kind of unusual real property interest, so that you can have some context as you look at the conservation easement that I know is a subject of a lot of discussion and analysis between the Clayton Trust and the City and County of Denver. And if there's specific provisions of it that you'd like to ask about, what's in it, what might not be in it, I'd be glad to do that. But I think my charge, and I take my charge today, to be just a little broader than that. So what I was going to do is talk probably for about 15 to 20 minutes at most, and then leave a lot of time for questions, specific questions or more general ones. So kind of starting at the very beginning, Conservation easements haven't been around in a formal sense for a very long time. They were created, authorized in Colorado by legislation in 1976. So the legislative authority to create this kind of property restriction that can be enforced by an entity rather than by a neighbor has only been around here in Colorado for about 45 years, and it was pretty obscure through the 1990s when it became more of a focus. But conservation easements, it basically are just enforceable restrictions on what can happen on property, and they're intended to be created to protect the conservation values of a property. They're granted under Colorado law. They have to be granted by the owner of the property, which is typically a private party. On occasion, it could be a governmental entity, but typically by a private party. But it has to be granted to either 501c3 conservation nonprofit. So a nonprofit organization recognized by the IRS. And I'm going to refer to that kind of entity is typically what we call a land trust. A land trust that you probably have all heard of is the Nature Conservancy. They're one kind of a land trust that work on an international level. But in Colorado, we have about 30 or 40 501c3 nonprofits that function as land trusts. Another example is Colorado Open Lands, which works on a statewide basis. There are local ones that work just on a countywide basis. So this conservation easement has to be granted to an entity like that, IRS nonprofit entity, or to a governmental entity. The city and county of Denver is a governmental entity, so it's proper that they're the holder of this Clayton Trust conservation easement. But because there are public and private benefits that flow from this, you can't grant a conservation easement to your neighbor. It has to be, to have the full authority of law in Colorado, it has to be granted to either that land trust, a conservation nonprofit, or to a governmental entity, and they have to be the holder of the conservation easement. So typically then what a conservation easement will do is it will identify the conservation values of the property that are to be protected. And those can vary. The common ones are wildlife habitat, protecting the habitat for elk calving grounds, for public recreation, where the property that the public can come on and do public recreation activities, or for open space purposes. And a conservation easement may have all of those, or may just contain one of those benefits. So if you saw my bio, you see that I've done about 600 conservation easements on probably now well over 1 million acres of land. And it's the wildlife habitat and the open space benefits that typically are the purposes for conservation easements. But the public recreation does show up occasionally. And so hiking trails, biking trails, a golf course would qualify as public recreation. So the conservation easement promises, typically in perpetuity, promises to protect those conservation values. And the conservation easement will have remedies for the holder so that they can hold the private party to these promises. It will limit further improvements on the property to maybe no further improvements at all, but it may be that it allows some improvements that are generally consistent with those conservation values. So a conservation easement that crosses my desk pretty commonly would be protecting a couple thousand acres of Colorado ranch land, and it allows some agricultural buildings on one small portion of the property and allows some new improvements within that in some limited sense, but it protects the rest of the property from ever being developed, subdivided, or built on, so that the wildlife benefits, the agricultural use benefits, and the open space benefits that come from that protection are protected forever. I said that these conservation easements are typically perpetual. In theory, you could do a conservation easement for just a term of time, like 10 or 20 or 50 years, but that's really, really rare. So what we almost always see are conservation easements that are done forever. And I think one of the places that plays out in this discussion is that the arena of this kind of private land conservation is designed not as kind of something temporary, but as something permanent for a community. And the benefits that flow from it are tied to those kind of forever promises. So a conservation easement, if you ask, well, why would a rancher, a rancher can keep ranching if he doesn't put a conservation easement on. Why would a rancher ever do this? The reason is that it can be complicated. One of the reasons always is that they care deeply about their land and they want to see it not developed. But there are some economic benefits that flow from it as well. Since 2000, Colorado has had a Colorado income tax credit for the donation of a conservation easement. So without going into the detail of how that works from a value and mathematical standpoint, somebody that donates a conservation easement can get a Colorado tax credit for the value that they give up. And that can be a substantial economic benefit. There's also a federal charitable deduction. Just like the donation you may make to your church or the Red Cross, the value of the conservation easement is a federal charitable tax deduction. And so a landowner who makes the donation of a conservation easement can get a federal charitable deduction for doing it. And that can also have some significant economic benefits. So that tempers the decision to give up the value of these development rights that every property has. But what we also see are the purchase of conservation easements by governmental entities at every level. In Colorado, we see it with Great Outdoors Colorado spends significant monies on what it deems to be special properties and will pay the landowner a value, some portion of the value of the conservation easement to restrict that property forever and protect what Great Outdoors Colorado deems to be the values of that property to our state. The Colorado Parks and Wildlife does the same thing. There are a number of Colorado counties that have conservation easement purchase programs, and that includes Arapahoe County, Douglas County, Routt County, and Steamboat Springs all have, and Jefferson County also, all have some public source of money where one of the things that they do with that is pay landowners to restrict the development of their property for the benefit of the entire community. An advantage to a landowner in doing that is they get, if they're not interested in developing the property and they think they're getting compensated appropriately, they will still get all the other uses of their land. If it's If it's 40 acres in Douglas County with not much on it, they get to use it for recreation purposes. Maybe they'll have a house on it. They can't do more than that, but they get to use the property for the things that they still value. A rancher or a farmer will get to still conduct the agricultural activities, make a living, do all the other things, but they will give up and sell the development rights. So they get some of the benefits from the property that they perceive are of value to them, while selling this restriction and giving away the development rights, which is something that they're not interested in to begin with. So we have programs at the state level, we have programs at the county level, and we have programs at the federal level that do the same thing through the US Department of Agriculture. So there is a lot of economic incentive for special properties to be protected with conservation easements. The most common conservation easements we see do tend to be a little bit in rural areas. You have more land, you have more habitat, you have larger parcels that have more open space benefit. The nonprofit that I do the most work for, the Colorado Cattlemen's Agricultural Land Trust, just by its name gives it away, it works in ranching communities primarily. But there are a significant number of conservation easements still used in urban areas. And a good example of that are a couple properties in Greenwood Village that back up to the Highline Canal and have parcels large enough that protecting the backside of those properties for the wildlife habitat and the open space for people using the Highline Canal is of benefit to everybody. So they come in all shapes and sizes. And in my history, the smallest one I've worked on is probably about 5 or 10 acres, and I've worked on some as large as 40 or 50,000 acres in size. So they come in all sizes and shapes. The conservation value of the property can come in all sizes and shapes as well. I am at a disadvantage, maybe good or bad, about what the motivation was for the Clayton Trust conservation easement to the city and county of Denver, that whether it was, there was some it has the usual lawyer language for good and valuable consideration, which tells you nothing at all. And I use that all the time as well. So that's not hiding anything, but I don't know what the circumstances were of that conservation easement being granted to the city and county of Denver and the context of that. And so that's just not saying anything of substance, just an observation for you. But I want to talk about kind of amending and terminating conservation easements and the national standards for those a little bit. And I'm doing it without really being a comment in particular about this conservation easement. For context about my comments is that I was on the committee that drafted the national standards that were approved by, these are industry standards, not governmental standards, but they're recognized by a lot of governmental entities. That the Land Trust Alliance, the umbrella organizations for land trusts in the United States, adopted standards and created an accreditation commission in 2006 that I chaired for the first 9 years. So I was and have been intimately involved with those national standards. Conservation easements are intended to have some perpetual nature to them. They are done in the context of protecting land in perpetuity. So that's a comment about the expectation created. It's not a legal comment. It's a comment about the expectation created by putting in place conservation easements. And I guess I hadn't thought about it, but I would say to you that this task force is kind of created out of that expectation of, what was this conservation easement for and why was it done and should it be changed? So it is a serious business to change conservation, even just to change conservation easements. Amending conservation easements is scrutinized by the IRS. The industry standards provide that you don't do that except very carefully with a neutral impact on the conservation values, and you don't give private benefit, meaning you don't give value back to the donor of the conservation easement. A basic requirement of 501c3s is that you're doing this for charitable purposes and not for any members of your organization, and you don't give what is given to you as a charitable gift, you don't give back. And that's a fundamental kind of concept of the 501c3 under the Internal Revenue Code. So conservation easement amendments are taken very seriously. Having said that, I've amended a number of conservation easements for a variety of circumstances, not routinely, but a reasonably substantial number where occasion and circumstances required it. Sometimes as simple as fixing a legal description, but sometimes adding land, but sometimes fixing some things that just weren't working on the ground, and we did it very carefully. Terminations are a step up in seriousness. So the Internal Revenue Code doesn't set the standards for conservation easement under Colorado law, but it does set the standard for conservation easements if you want a federal charitable deduction. And there, the Internal Revenue Code provides that you really shouldn't terminate conservation easement except with a judicial proceeding where the conservation values of the property are no longer capable of being served. The industry standards provide that terminations should only occur in rare instances and with that kind of judicial action. And in 2019, the Colorado law was revised, and I know that some legal analysis was given regarding the Clayton Trust Conservation Easement and how it complied with Colorado law. And I'm not making a legal comment to you about that letter or what's right or wrong about that issue, but the change in Colorado law in 2019 also says this is a serious business to terminate a conservation easement. Excuse me for the water break. So those are the general comments I wanted to make about conservation easements and what they are, and give you a little sense of how the community of private land conservation views them. And I think at this point I would just be glad to answer. I'm gonna step aside for 10 seconds, Dr. Ross, while I get my other bottle of water so that I get through this, and I will be back, and then I'd be glad to take any questions from anybody.
Perfect, thank you. So our questions, we'll start with Mohammed, then Lisa, then Evelyn, then Kenneth.
Okay, there we go. Thank you for that.
All right, our first question is from Mohammed.
Yes.
Mohammed, you can go ahead and ask your question.
You're muted.
Oh, sure. Sorry, I wasn't sure if you were going to read it or you want me to ask it. It's a two-part question. The first one is, if you were to grant an easement to a person or for-profit business, would it be a lease instead of a easement?
But the question was, could it be a lease? Is that the question?
So if you grant an easement to a person or a for-profit, it won't be an easement. It would be called something else, right?
Yes.
What would it be called in that case?
Well, there are a lot of different kind of easements, and an access easement is an example of that. There are easements that allow access across properties. So conservation easement in gross has this particular authority to exist under Colorado law. And so you can only be that if you satisfy the Colorado legal requirements. But there are numerous public utilities hold easements. That's how we get our telephone lines and power lines. So all of those are just various other kinds of easements, and just a different version for a different purpose. All of them have in common is that they leave the underlying ownership alone, and somebody has a right to use that property subject just to the terms of that easement, but it doesn't change ownership of the land.
Thank you. The second part is so you talked in detail about benefits of conservation easement for businesses, and they get the nonprofit. They get the tax break for in the conservation easement. What benefit does a nonprofit get for granting conservation easement?
Well, under Colorado law, a nonprofit that owns land and makes a promise, grants a conservation easement to another nonprofit, would be eligible for the Colorado conservation easement tax credit. And it actually did happen in Larimer County near Estes Park, where I believe it was the YMCA owns land, and they could have sold it to somebody to build on, and they granted a conservation easement to the Estes Valley Land Trust, and the Colorado tax credit allowed them to get a tax credit for that. So that's pretty unusual. Under federal law, a 501c3 doesn't have income, so it doesn't have anything to use the charitable deduction to offset. But private trusts, where a family has ownership in a trust, that can generate the tax benefits both at the federal and state level. I don't know enough about the Clayton Trust to answer exactly where they would fall in that.
Thank you.
That answers the question. Thank you.
Thank you so much. Lisa? You're on mute.
Okay, am I unmuted?
Yep, you're
Yes,
good.
you got it.
So I'm trying to understand what we just talked about and how it actually relates to the Park Hill Golf Course. Because what I was hearing about was Colorado law, and then having an exchange to a governmental entity like a city or a 501c3. But in this instance, it seems to be that there's an easement that I was reading in our stuff. I appreciate you guys posting all that and making it available to us. This conservation easement seems to be between the city and a for-profit developer. And so it seems different to me. And I'm trying to understand how what you're talking about in state law, does this, so I have two questions. One of them is, this conservation easement that I read seems to be between the city and West Side. And so, and they actually have provisions in there where this could be vacated, like this could be ruled null and void. So I'm trying to understand how this is actually the same as a typical conservation easement that you've described. This seems to be very different to me. And I'm just trying to, this agreement seems to really be between the city and West Side, does it still follow state law? Because it does allow for to get out of this, I guess, if they use eminent domain and other things like that.
Well, yeah, let me take kind of a couple, break that down to a couple answers. The conservation easement I was provided is the Clayton Trust to the city and county of Denver. So that's that's the only one I have, and I know them. I'm aware of the developer that's involved with that property. But it in terms of being a proper conservation easement and gross under Colorado law, it is from a private entity, a private landowner, to the city and county of Denver, which is a governmental entity. So it satisfies that part of the Colorado statute that it has to be granted to a governmental entity. This is more than just an agreement among two parties. It's a conveyance of a real property interest to the city, and it does that. Now, a condemnation clause is not uncommon in a conservation easement. Think about, the kind that I run into are oil and gas pipelines. Oil and gas pipeline companies have the power of condemnation in Colorado. And once in a while, they condemn a pipeline through land where my client holds the conservation easement. And they get to do that, and it terminates the conservation easement over that part of the property. So any conservation easement is going to be subject to, in Colorado, is going to be subject to the power of entities to condemn. The state, cities, oil and gas line pump companies, and utility companies. Many entities have that power of condemnation, and a conservation easement doesn't trump that power. So it is not uncommon to have a provision that here's what happens in the event that that condemnation takes a part of the property. The specifics of this condemnation provision, it would help to understand the transaction a little better, to understand exactly what it was getting at. But one of the things it does get at is this concept about the grantee getting a certain amount of value. That is common, and I'm looking at it, and I think I'm trying not to read it at the same time that I talk, but I think what it says is that in the event this whole property were condemned by somebody, the city has an interest in this property. They've got some development value of it, and they should receive something in exchange for this if the state of Colorado condemned the whole thing because they want to put their CDOT headquarters and all their trucks there. The city would get 25% of the value of that. That's a common provision in conservation easement and actually required by the Internal Revenue Code and the Treasury regulations. So that's not uncommon to have a provision in a conservation easement that deals with that possibility. This is a little more extensive, and I don't know kind of the background of how it got to that, but the provision in here is it's not unusual to have that.
So sorry, just a quick follow-up though, but
Sure.
I do feel like the background on this is really, really important. And I'm a little disappointed that we're not talking about it, because I've been in Denver a long time, and my sense was that my personal opinion was that this was a bad public policy decision for something that they wanted. And it was a tool that they used in a clumsy way back in whenever, 1990, because they wanted to keep a golf course and they wanted a nonprofit to run it. But then the nonprofit didn't really want to run the golf course anymore. So they leased it out to someone else. And then they didn't want to do it anymore because they were losing money. So then they sold it to a private developer so that the nonprofit could make money. It just doesn't seem to, this tool seems very clumsy to me that we're using it in general. Just my non-legal opinion.
Let me avoid commenting on the public policy. Not that I don't have an opinion about it, but it kind of wasn't what I was asked to do tonight. And I don't have, I was a resident of East Denver for a long time and now live in Capitol Hill. So I'm aware of the Park Hill Golf Course and a little bit of the history of this from the newspapers, but I don't have enough knowledge to answer your to answer your question. And if this group wanted me to, you want somebody to do that, you should ask that. If you wanted me to, I'd think about that. But I'm
Yeah.
not knowledgeable enough tonight to do that. And my charge was just to give you a little bit bigger context about conservation easements and how they work and how they're used. And tonight, that's about the most that I can do for you. And I understand the question you're asking, and I'm not, somebody who knows more about that than I do. Right?
Mhm.
So
Okay.
I hope I politely dodged part of that question.
Yeah, okay.
Thank you. Evelyn, for our next question.
Thank you so much for being here tonight, Mr. Keeter. Is that pronounced it
Yes.
correct?
You did, thank you.
I'm going to be fairly succinct in my questions. I formulated a few of them, but I believe that they kind of overlap with one another.
Okay.
So hopefully they make sense. The first question is, can you please clarify or reiterate that, quote, amending a conservation easement is actually legally possible? And if so, is it as long as the parties involved agree to that amendment? Along those same lines, you also mentioned or seem to imply that there are some levels of severity or gradations, if you will, in lay terms, as it pertains to amendments versus terminations. And so I'm wondering, in terms of if you could kind of carve out or even maybe provide an example of the levels of severity associated with an amendment to a conservation easement versus an actual termination for us as well as the listening audience. And thank you so much.
Sure. So amendments are, I'll take a step back to what the conservation community, meaning kind of land trust community, believes that it's providing and offering to the public, which is we're willing, they're kind of saying when you go to talk to a landowner and sit at their kitchen table, you're kind of saying, are you interested in protecting your property forever? If you are, we're willing, that's a serious promise, and perpetuity is a long time, however long that is, but we're willing to undertake that promise. So it's at the core of private land conservation in this country. I make that promise to ranchers on behalf of my clients. I've advised landowners about it. So it's a serious promise and commitment to make. So, and in that, consistent with that, we don't view conservation easements as fungible. And what I mean by that is we don't think, well, we've protected 40 acres over here to do this and not the 40 acres a half mile down the road. But it would really be better if we just flip those and put the houses over here where we've said we're going to conserve it and conserve the other 40. And so let's just terminate this one and we'll do it over here. They're not viewed as, by the conservation community, they are not viewed as fungible in that way. So because they're not, amending them is a serious business. But I've amended them to correct legal descriptions. I've amended them to add more land. That makes a lot of sense. I've amended them because a place where a house could be built turned out to be unbuildable for some geologic reasons. So we moved that. We've amended to clarify some provisions. We've once or twice amended conservation easements to resolve some disputes, but we have a set of standards within which we'll do that. And the two fundamental ones are that we will not compromise the conservation values, and we won't give back economic value to the landowner. And if we satisfy those two, then we've got some room to do it. But it's a business to take seriously and not casually. Within reach here, I have an 80-page book from the Land Trust Alliance about how to do it well. So it's enough, it's a serious enough business to write write a book about. Terminations are a step up in seriousness that you can imagine, especially with the economic benefits. The state of Colorado isn't interested in giving a tax credit to somebody for protecting their land and then 10 years later having them terminated and do it whatever they want with it. So the state of Colorado has an interest in that because they have invested economically through the tax credit. The IRS has an interest in that because they've allowed a federal charitable deduction. But so it's very rare and it's treated that way. It does occur. It's also the smallest conservation easement I'm aware of that's on about a half acre of land in Savannah, Georgia. And it is protecting the largest live oak tree on the planet. And they did it to make sure that nothing interfered with that live oak tree. But when the tree dies, that's going to be the end of the conservation easement. And that's probably appropriate. It's also a very uncommon example. The more common example is condemnation for sometimes county roads need to intrude a little bit on a conservation easement to widen for safety. Oil and gas line pump companies have condemnation powers. The state does for reservoirs, and there the conservation easement just as a matter of law takes second place to those condemnation powers, and that's the place where we really see it. We do not and do not encourage termination just by agreement of the parties. That flies in the face of the fundamental notion of private land conservation, which is this property is worth saving for these conservation values, and we, the nonprofit, will help you do that. And to turn around and just terminate it is really inconsistent with our charge. So that sounds like a comment on the Clayton Trust conservation easement, but it's not meant as that so much as a description of how terminations are viewed in our land trust community. And they are viewed as something to only consider in the most rare of circumstances. And I was just reading the standards that I helped write about 15 years ago, and those are the words that are used. Terminations should be considered only in very rare circumstances.
Thank you.
Thank you. Our next question is from Kenneth.
Dr. Ross, thanks, Mr. Keeter, for joining us tonight. So I appreciate that you're providing a lot of perspective on what or kind of and I understand that you probably write, or you have written hundreds of these, and you write them all in the spirit of your understanding of it.
Yes.
But I want to just go to the actual words of the easement itself, just because I think that it's pretty critical here. And I think that also, am I correct in saying that the state statute essentially says that the particular characteristics of a conservation easement are those granted or specified in the easement itself, which means that basically all of that is, the actual easement itself matters.
Yes.
Right. And so, and then with that typically the series of statements, the whereas statements talk about titles, and that those typically kind of establish some overarching intent of the agreement and the parties.
Yes, that's true. Exactly.
And so on the very last whereas statement, the last sentence there, can you explain what that means when it talks about that they want to convey a conservation easement with a golf course unless otherwise, pursuant to the state statute, unless otherwise provided herein and subject to the terms and conditions set forth herein? That's a lot of legalese. What does that mean?
Well, I think what it told me is The last couple lines are kind of lawyer boilerplate, but it said the purpose of this conservation easement was to preserve the golf course as open space. I mean, that, you know, it's right there. And so that was the intent at this time in 2019, and common, you know, in the recitals to describe the intent of the parties. And I think that's what that does.
And I was asking specifically that last sentence that says, unless otherwise provided herein and subject to the terms and conditions set forth here.
That looks, I'm not sure, you'd have to ask the lawyers who wrote that. It looks like a lawyer trying to create some wiggle room is what it looks like. That's not language I would typically use.
Right, but it's in there and it was specifically put in there probably for wiggle room,
Yeah,
right?
it was. I would also, I mean, I'd also say that, you know, that's not, it's for other people to debate whether this conservation easement is subject to the changes in the law in 2019 or not. I'm not going to opine about that, but I would tell you that I don't think this exempts it from complying with state law by doing that.
Yeah, so it sounds like they may have intended some wiggle room there. The other question I have is paragraph 15 of the easement itself.
Mm-hmm.
The one titled amendment, again, specifically around that, it specifically describes, we just talked about that the agreement matters itself. What does that amendment paragraph say to you?
What I'm saying is just something very simple, that it has to be done by both parties and recorded. And that's a conservation easement. The legal documents we use have grown and become much better over time over the last 30 years. And you might see that simple a language in the easement done 30 or 40 years ago, but now it would typically say, you know, that it should be done considering the kind of requirements I just described here.
Yeah, I understand
says
that,
you know, it can't be valid unless both parties sign it and it's recorded. My conservation easements say that as well. It also would include having some standards about under what circumstances could you amend it, and this is silent about that.
right, but the language very plainly, just reading it says
stepping in. I don't mean to cut you off, Kenneth. But stepping in just to keep us on track. We've got about 12 minutes, and we've got 4 more questions that I want to make sure we get to, and I also want to make sure we stay on general easement and not dive too deep into the specific Park Hill conversation. But feel free to, but everybody feel free to ask your questions.
And I appreciate that, Dr. Ross. I just wanted to note that there's typical and then there's the actual details here, which differ. So thanks so much. Thanks for your time and your
thank you.
Sure.
All right. Okay, Sandy.
Of course you would call on me, Dr. Ross, right when my phone is acting up. Oh no, actually here it is. Okay, so here's my question. Can you hear me okay?
Yep, you're good to go.
Okay, all right, good. What are the requirements? Thank you. Thank you to our guests for being here this evening. So my question is, what are the requirements under Colorado law for terminating, releasing, extinguishing, or abandoning a conservation easement? I think that's pretty general. Thank you.
Sure. So in 1976, when the Authorizing Act was adopted, it was a very simple provision. Conservation easements were a very new thing at that time. And so the Authorizing Act in 1976 simply said that easements can be amended, changed, terminated, just like any other easement. And that was in Colorado law until 2019. I had the change in 2019 up on my screen, but it's lost, so I'll have to paraphrase it. in 2019, the legislature made changes to that clause and said that you could only terminate a conservation easement by judicial proceeding or by condemnation. And there's one other clause in there. And I think it said that you couldn't terminate a conservation easement that had received a Colorado tax credit that was to protect the kind of economic investment of the state. So right now there's a much more extensive clause that has a process for termination and requires a judicial proceeding to do that. I don't believe any standards have ever been proposed or adopted about what the standards for that should be. There's a little bit of it in the legislation itself, but as of whenever the 2019 law took effect, since then the requirement for termination includes a judicial proceeding and the consent of both the consent of the parties and a judicial proceeding.
Okay, thank you. We've got Imam, and then Sean, and then David, and that'll be our last question.
Yes, the conditions of the easement matter, and I want to know, is the easement considered open space?
I think the answer is that is the language in the recitals of the conservation easement, that the purpose of it was that it was being done to preserve the golf course as open space, and that's in the language of the easement. So that was certainly the stated intent of it in the document.
Thank you.
Sean?
Thank you. I've got a couple, and I'll try to be really quick. You've mentioned a couple times background on the surrounding environment when the easement was created. And I see a few times it talks about a daily fee, which I think there's an emphasis on that versus private. Would that matter? Like, you talked about the context of when it was created. Would that matter to you?
I don't think so. I think
Okay.
the use, it's really about the land and the use of the land. And if
Okay. My other question is, and I'm looking at the easement documents as well, the condemnation, which is section 7 on page 3, is all about eminent domain. And I don't think I'm wrong to say the city used eminent domain to shut down the golf course to build the drainage for I-70. And I mean, that looks like fact to me that that's what happened. So does that muddy the waters now to the city took an action that has undermined the ability to use the golf course?
I'm not sure I know the answer. I'm looking at the kind of words, but I'm not sure without a little more context and a little more knowledge about the storm drainage that I know the answer to that. It was to preserve the open space. Golf course is open space. Doesn't matter whether the golf course can still operate. It can still be open space even if there's no golf course there. So,
well, but this says if there's no golf course, it goes away. And I'm reading the text here. If the easement, terminate the easement upon tendering said amount. If there's if eminent domain that it is no longer physically possible to operate a golf course, grantee shall have no claim against grantor for any portion of compensation, and grantor shall have the right to terminate this easement with written notice of a letter. I mean, that seems pretty like, if you make it not a golf course, I can make this go away with a letter.
Well, I wasn't aware about the storm drainage issue, so I see the words and I think that's a fair question. I'm a little reluctant, kind of looking
And that's,
time with that.
I get
to
it.
answer the question.
You know, I
I understand the question, and I don't know whether that storm drainage was contemplated at the time, and so I think that's as much as I should answer. I just don't know enough about the background of those words to tell you tell you one way or another what I think about them. So I'm a little reluctant to.
well, and I mean, I appreciate you don't know the surrounding, but if eminent domain was used, does that allow the grantor to terminate with written notice?
I saw the things that I don't know are how much was taken, how much is left, is that enough to run a golf course? So there are all kinds of questions involved in that, but you're right, they have words in here about about the golf course, and if it can't be used for that, a right to terminate. I don't know, I have enough of the facts to know whether that is really provable or not. I think that's why I'm a little reluctant to do.
Okay, I mean, but that
Sean,
okay.
yeah, you're getting a little into the weeds there with questions that probably have to be answered somewhere else. But you said you had a second question?
Well,
You did it.
I guess and I'll back off the weeds, but in general, it seems that I lost my question here, so I'll go from there. Thanks, Dr. Ross.
All right, cool. Thank you, Sean. David.
Thanks, Dr. Ross, and thanks, Mr. Keeter. Is that?
Yes.
Keeter. Yes, Mr. Keeter. I have essentially 3 questions. They should be very brief, but to lead off of some of what was going on in the conversation before, I think where people may be getting a little off kilter is the concept, and what we've all heard a lot about, the concept of conservation purposes versus permitted uses. And certainly this conservation easement as it stands today has its purposes defined in the document, and it has its uses defined in the document. And I'm not going to ask you to elaborate on either one of those two as it pertains to this particular conservation easement, because I think that's fair and unfair and out of bounds. But can you elaborate a little bit on what these two concepts are and how they do exactly differ as it relates to a conservation easement, so that we all understand that?
So what I would tell you is the conservation purposes are really doing 2 things. They're talking about the characteristics of the land and why it is worth placing a conservation easement on the land. So it is a description of that, and that often gets to kind of what the intent of the parties about, the intent meaning the why of it's being done. The permitted uses then are the kind of practical side of what, having described what the characteristics of the property are that are intended to be conserved and kind of the why of it, the improvements, the permitted uses are really about, okay, what can you do specifically that are consistent with the conservation values you've described? So so here there's description of a golf course. To take it back to the more general, we do conservation easements on a 1,000-acre ranch, and it's described for its agricultural, open space, wildlife habitat. And then we will describe 1 10-acre headquarters area where you can put 2 houses and as many agricultural structures as you want. So there, we're describing the property and the intent, and then how we carry that out is in the limitations on what can actually be constructed. So that's how those 2 things mesh together.
Okay, thank you for that. Real quickly, and I'll move through this real quickly. I think we all know that the Park Hill Golf Course land is subject and pursuant to the Colorado Conservation Easement statute. I don't think there's any question with that. Are you aware of any conservation easement that would not be subject to the impossibility requirement as stated therein for terminating, extinguishing, abandoning, or releasing a conservation easement? Or are all conservation easements, regardless of how they are, subject to that rule?
Well, I used to be a municipal attorney, and so I understand the concept, of kind of balance of local authority and statewide authority. And I would tell you that I don't think cities have the power or counties to exempt themselves from the Conservation Easement Enabling Act on the basis of some home rule matter of local interest. So the answer is that, this is off the top of my head because I hadn't thought about that question until we've been on the phone tonight. But I would tell you that if you're going to create something that you call a conservation easement under Title 38, and they do, that yes, I believe you are subject to the conservation easement laws of the state of Colorado.
Okay. And then finally, if you do an amendment to a conservation easement, does that amendment have to be consistent with the conservation purposes? As there are established,
Well, I think it does for any number of reasons. I'm not sure I can point you exactly to the statutory provisions in Colorado where it would say that, because I'm doing that off the top of my head. So yes, I think, and when you think about this, how this has been created, describing property, why it's of value from a conservation standpoint, you're protecting that, you're taking advantage of the state laws. To do that, you shouldn't be amending it to damage those conservation values. And I think if it's not expressed in the law, it's implied in the law is the position I would take.
So you're just fine. When you say values, does that mean purposes to you?
Could you say that? You faded a little bit. I couldn't hear
You used
that.
the word values. Does that mean purposes to you? Conservation purposes, are those one and the same?
Well, the conservation purposes will bear on, yes, how you might amend it and how you consider that. Can you protect those conservation purposes in the process of amending a conservation easement?
Okay.
Did that answer your question?
Yeah, I think you did. I don't want to, we could talk all night, but let's not do that.
Cool. Thank you so much, David and Mr. Keeter. Thank you so much for being with us. We really, really appreciate your time and expertise and spending it with this group tonight. So everyone, there's a lot of information, and so definitely soak it in, come back and re-listen to this, and then if you have additional questions, that didn't get answered, or please email those to me, and I'll do my best to see if we can get those followed up with. Larry, did you have something?
No, I'd be glad to to be a part of further conversations. You can tell there's a little bit of tension with me talking about the generalities here versus the very specifics of it, and because I didn't, while I looked at and read the conservation easement in dispute here, I didn't spend a lot of time thinking about that. So just with that caveat, I'm glad to be a resource if that would be of help. I was glad to spend time with you tonight.
Right on. Thank you so much. We really appreciate it.
All right. Thanks, everybody.
Cool. Give Larry a quick round or a handshake or something for being here. It was not easy finding an expert that quickly and who was also available and willing to come talk about this. And so Larry, we really, really appreciate you and just thank you so much for being with us.
Glad to do that. And I will let you get to the rest of your business. Good night.
All right. Well, we are going to keep moving. At this time, we're going to turn it over to Patty And is it Patty? Is it Iwasaki or Iwasaki?
Iwasaki.
Iwasaki. Thank you. So Patty Iwasaki is here with us, and this was one of the other topics that you wanted to spend some time talking about. I know that the agenda said 7, probably should have said 7:30 like we normally do, and so we'll probably, you know, be a little longer than 7 tonight, and hopefully that's okay. We won't go past 7:30, but I want to make sure that you guys get this information, and we also have time to get to our 6 folks who are on the public comment list. Is that cool with everybody? All right, and then if for some reason you've got to drop because life happens or you got things to do, totally understand, and we can follow up accordingly if necessary. But at this time, I'd like to turn it over to Patty, and Patty, you can control the screen, I believe, or if not, Courtney will manage the screen with your slides.
Courtney, can you, I'm just going to jump in. I assume that everyone got information about me and some of the resources.
Mm-hmm.
So can I rely on you, Courtney, to do the...
Yes. If you could give me 2 seconds to pull that up, or just start talking, and I'll try to get this up real quick.
Okay. I was, let me just begin. I believe that the reason why I was asked to speak on this is I just finished teaching a food systems and food justice course at DU to the School of Social Work. I'm not a farmer. I am a social worker. I have a behavioral health background. It's nice to see Jerry and Reverend Downing here. And I have lived in this northeast portion of Denver for many years and have been in Colorado more years than growing up in Los Angeles. But if we can get the first slide, I'll just jump right in.
Patty, I don't see the slide. It must have been sent to Dr. Ross, because I just have your synopsis of interventions with scientific evidence of impact for food security.
Okay, let me see if I can.
I'll send that to you right now. Give me 1 quick second, and we will.
Let me see if I could do this. Can you see this? No.
No, give me 1 second and I'll get that.
Okay.
This would be a good time for bathroom break for anybody.
Yeah.
Please get a bathroom break, or if you haven't got your 8 cups of water in today, go get 8 ounces. Take care of yourself, and 2 minutes and we'll have this slide up.
Oops. I'm going to try and get this off my screen. So all right, there we go.
All right, Courtney, that should be heading your way right now. And apologies all, this is what happens when you email from rural Africa. Sometimes the stuff doesn't make it all the way through. So I apologize for that, but we will.
Yeah, I had sent this out to the 4 people. But I'll speak to the folks that are not taking a bathroom break. I was told to speak specifically about food insecurity, food deserts, and just the local food system. So the material that I had sent over, I just have 8 slides, and was told that that I would be speaking for 10 minutes. And in the handout material that I believe everyone got, what I tried to do is include those effective food system programs. It is a document that was drafted by a pediatrician that serves on the Healthy Food for Denver Kids Commission, one of the commissions that I serve on currently. And I was also a member of the Sustainable Food Policy Council for Denver for about 6 years, which exists at the generosity of the mayor. It's not written into charter, so the responsibilities and actions of the Sustainable Food Policy Council can go through a change because it's not written into charter in terms of their work with the city. And are we still having difficulty with the slides?
I have not received an email with the slide. Is there?
Let's see here. Let me try one more time.
Dr. Ross, is it possible that you could share your screen?
I can, but my screen is on an iPad and my computer is separate, so I can see things and do research on the side for you guys. And I would have to log out and log back in to do that. So give me.
Let me see if I could do this.
Actually,
I have the ability to share the screen. Is that correct?
Courtney, can we give Patty access to share her screen? That'd probably be the fastest way.
I've made her a co-host. Maybe that will work.
Okay, let me see if I could do this.
All right, and apologies for the technical difficulties, folks.
Oh, it just came up. Your email just came in.
Okay, cool. Looks like I was emailing over dial-up, guys. Sorry.
Let's see here. I'm going to share the screen right here.
Great.
And you can see that we're looking good.
Yeah.
Good.
And if we can just, yeah. So a community food system, and this is, I chose this slide because it's the most basic, elemental, usually includes all those folks that are involved in production, processing, if it's processed food, even in, for people who are involved in growers or CSAs, it might be just getting food prepped to be able to go to the next step, which is distribution, transportation, marketing, the purchasing in terms of who is able to access the food, and whether it's purchased through like some of the local producers operate CSAs or the cooperative sharing, purchasing portions of their food allotment. Preparation and consumption would be all of those folks that, whether you cook at home or you purchase from a local vendor or market, etc. Waste, then onto waste recovery, nutrient cycling, and because I am involved in some of the ecological aspects, this is a big area where Denver does not all partake in composting and the recycling process. And then it's a closed system if all of those elements are at work. Next slide. So, as I said, the local food system includes all of these various aspects. During COVID, where so many people were laid off and out of jobs, distribution and transportation became a key bottleneck in terms of people being able to receive food. The fact that kids were not in school, all of those populations suddenly were flooding food banks, and food banks also suffered because their traditional use of volunteers from the older elements of the community suddenly broke down. So a number of food banks went under during that time period because they were not able to get processing and get food out to their local community. Community food security, I'm using a definition that was from 1995. All persons obtain at all times culturally acceptable, nutritionally adequate food via non-emergency sources. I'm going to just out of order go to food insecurity, which the USDA uses a household level determination of food insecurity, and that is the economic and social condition of limited or uncertain access to adequate food. So in Colorado, the hunger-free community, as well as the Hunger-Free Colorado group, did a study in December of 2020 and found that 38% of the population was food insecure, and of those, I think the non-white Latinx community was 52% food insecure, and versus the white population being about 30% food insecure. This is still a tremendous jump from previously, where the estimates in 2019 were for the general population about 10% being food insecure. So no surprise, but just in summary, because of COVID, in low-income BIPOC communities, Black, Indigenous, people of color communities, food insecurity shifted from being maybe 12 to 15% to suddenly 30 to 40% in those communities. Food desert, which I was asked specifically to define communities with low access to healthy food or without grocery stores, or grocery stores that had food, but most of the time they were fast food, kind of prepared packages, no fresh produce or fruit, and have been the target in terms of those communities with convenience stores as the main source of food for those neighborhoods. They have been like a target or focus from the Denver Department of Public Health and Environment to do corner store programs so that they could enable these vendors to have and work with local producers or farmers to provide fresh fruit or vegetables. And then finally, the last definition, hunger. Hunger is an individual level physiological condition. I am quoting from the USDA, most often resulting from food insecurity, which is not surprising. I worked with a community organization that did a survey in 2007 in the Northeast Park Hill community, which was one of the higher neighborhoods with food insecurity, and we found that when we talk to people and ask them, when you do say that you have uncertain determination of obtaining food, what do you do? And in many of the cases of talking to people in their homes or through their neighbors having meetings in their homes, they would say that they would try and provide for the children, and then they would eat like a snack at work, which is usually something from a vending machine. I don't think that that's unusual. That's been the case that we've seen with a lot of families that face food insecurity. Next slide. So the top quote is from Michael Pollan. Food, poor nutrition in particular, is a risk factor in 4 of the 6 U.S. leading causes of death: heart disease, stroke, cancer, diabetes. And then this goes through a number of food justice definitions. I'm going to just pick out the middle definition. Food justice is a holistic and structural view of the food system that sees healthy food as a human right and addresses structural barriers to that right. The bottom definition, which is from the Institute of Agriculture and Trade Policy, cited by this group in Oregon: the right of communities everywhere to produce, process, distribute, access, and eat good food regardless of race, class, gender, ethnicity, citizenship, ability, religion, or community. And the next slide. So this is both of these maps, the next one you'll see, but are from 2019. So it's just graphically, you're able to see the city of Denver and the percent of children living in poverty. It is not surprising if you look above North Park Hill. Northeast Park Hill has both a high percentage of very, very poor to somewhat in terms of their definitions, which is somewhat is 27% to 40%. So the map shows poverty is not equally distributed through all the communities. That's kind of a duh, as they say in my colleges that I teach at. But you're able to see that Northeast Park Hill is a very high low-income poverty area. And the next slide, go ahead. This shows the percent of the population that does not, that lives in a neighborhood where there's not a grocery store, a full-service grocery store. And you can see that Northeast Park Hill lists in that category. A full-service grocery store is defined as having healthy options such as produce and then availability of other resources. And in a public health publication, their definition of food desert is areas with low or no access to healthy food, commonly low-income urban areas without accessible markets or fresh vegetables or fruit. As I said, for example, in the Park Hill area, opposite the golf course is a Walgreens. They now carry one refrigerated shelf of produce. That is as a response to the campaign for corner stores that the City of Denver food team took up to make sure that some of the local markets have access. I think that's the end slide. Is there another slide after this? Oh. So a year and a half later, COVID and its effects, unemployment estimated at 9.7, average US unemployment 6.3. Colorado currently is 6.2, and Denver is listed as 6.5. That's as of April. SNAP benefits were extended to September of this year, with households to receive $100 increase per month. Though the thing that has to be said about SNAP benefits is if people applied for some of their benefits and whatnot, in other words, they received certain stimulus checks, it's not necessarily assumed that their SNAP benefits were changed in any way unless they specifically made sure that they completed all the paperwork to ensure that their SNAP levels remain the same. School closures forced a dependence on innovative delivery programs, especially during COVID. Programs like Bondodosa and We Don't Waste delivered food to a number of food insecure families throughout the city, but those are only 2 programs that were working. There were a few others, and if you got the handout that I had cited, it lists a number of different innovative programs, particularly within our Northeast footprint, where people were having food delivered. States also obtained Families First Coronavirus Response Act funds through a USDA pandemic electronic benefits transfer. Most, and I'm going to say this as a general rule, most farmers markets that exist throughout the city try and have available the pandemic EBT machines to access funds to utilize at these farmers markets. And while local food banks increase their caseload 3 to 5 times, if you'll go to the last slide, some of the lingering impacts, as I mentioned before, small church-run, culturally aligned food pantries in existence for years lost staffing because they lost their volunteers, or they lost funding sources because when a lot of these were incapacitated for months, a lot of the federal dollars that were coming down were going to certain areas. And Sandra, I'll just try and finish these last few points, and then hopefully Dr. Ross will get to you. The corporate donations during that time period of COVID went to primarily like Food Bank of the Rockies and some of the larger food banks. And so there were gaps in the distribution infrastructure. There are still today the point C, people seeking food assistance are 3 to 5 times their previous weekly numbers. In other words, there were certain locations throughout the city where what they used to serve on a monthly basis shifted to 3 times that on a weekly basis. And then finally, the growth of Spanish-speaking population in Northeast Park Hill do not frequent some of the local churches that have pantries. Instead, they seek assistance via some of their schools, culturally aligned institutions, health centers, or their churches. Also, families of longtime Park Hill residents who may live outside of the area may feel more comfortable coming to Park Hill to get assistance for food needs. And so I will allow Dr. Ross to call on Sandra, or I'll just ask her to raise her question.
So actually, what we're going to do in the interest of time, is I'm going to have folks, if they have questions for you specifically, I'm going to ask you to email those to me, and Patty, I'll email those to you, because I want to make sure that we get to our community members. It's really, really important. And we're a bit over time, and those voices are we want to make sure that we capture them and we don't lose them, because they've been waiting patiently since 5:30. So if you have a question for Patty, just shoot me an email. Let's give Patty a round. Thank you for this really great, informative information. And thank you for all the follow-up information that you sent, so folks can go out and do some more research and potentially answer some of those questions with your research. Just profound information, and we want to thank you so much. So let's give Patty one more round, or wave, whatever you can do from your screen. All right. So we are going to transition to our community, our public comment section. We have 6 folks who are registered to give comment. As per usual, they'll have 2 minutes to share their thoughts with you. So definitely tune in and listen to those folks. And right at 2 minutes, for those of you who are getting ready to speak and listen, I'll be stopping you right at 2 minutes, because we want to, again, be respectful of everybody's time, but be sure that we get to you. So our first speaker, Courtney, if you are ready, I have Woody, I think it's Gramsey.
Yep.
Gramsey.
And I promoted Woody to a panelist, so whenever you're ready with the timer.
All right, Woody, thank you so much for being here, and the floor is yours for 2 minutes.
Good. Hey, I'm a retired attorney and a member of Save Open Space Denver. To date, this whole process has been totally biased in favor of Westside's development plans in many ways, including on the issue of what the conservation easement actually means. First, the entire CPD effort is supported by Westside's development plans, and we know that CPD considers Westside to be the city's client in this process. Second, both on the CPD website and in these meetings, the city has presented its restrictive easement interpretation, that if the easement is preserved, the land will always need to be a golf course. Third, SOS strongly disagrees with the city's restrictive interpretation, and we've been trying unsuccessfully to present our interpretation. We've requested that CPD post our interpretation on its website to allow SOS to provide written interpretation to the steering committee, and to allow Penfield Tate to make a presentation at a steering committee, but to date, these requests have all been refused. Very simply, there are 7 essential parts of SOS's easement interpretation. First, it is governed by Colorado Conservation Easement Statute. Second, under the statute, it can't be terminated, released, extinguished, or abandoned unless a judge rules that based on changed circumstances on or surrounding the land, it has become impossible any longer to fulfill the easement's conservation purposes. Third, its conservation purposes are open space and recreation. Fourth, golf course operation is only one of its permitted uses that must be consistent with the open space and recreation conservation purposes. Fifth, if Westside doesn't want to operate a golf course permitted use, it and the city could amend the permitted uses as long as they're always consistent with the open space and recreation conservation purposes. Six, this expensive and time-consuming process is wastefully putting the cart before the horse, because the land cannot be developed without a prior court order of impossibility under the Colorado statute. And finally, there aren't any facts that would support a court order that it's impossible any longer to fulfill
Woody,
the easement's open space, recreation, conservation purposes.
You've hit your time.
I'm finished.
Woody.
I'm finished.
Okay, great. Thank you so much. We appreciate you for being here. The next person we have is Amy Harris.
Hi, everyone. This is Amy. I live in Northeast Park Hill here on 35th and Birch. And thanks for an interesting meeting tonight. I really enjoyed listening about the conservation easement aspects. That was, gosh, that's just so important to this conversation. I'm really glad there was emphasis put on that. And then the food insecurity, gosh, that's something that's also pretty near and dear to my heart. I'm not representing the state here, but I do work in the state's Division of Food and Energy Assistance. And food insecurity, it just blew up during the pandemic, and it's such an important issue. But there was one aspect of the presentation that, and this has been kind of ongoing, is that the presenter mentioned the Walgreens, and I know that Walgreens well. I go to that Walgreens all the time, and they do have that one sad little refrigerator. But just right up, just a few blocks away from the Walgreens, there's this awesome grocery store called the Park Hill Grocery Store off of 40th in Colorado. And I mean, the first thing you see when you walk in there is just rows of fresh produce, and meat and seafood and frozen areas where they have refrigerated foods and frozen foods and packaged foods, and it's full service, and they celebrate Chinese New Year there, and they have an awesome taco truck in the parking lot. I mean, this is a legit full service grocery store that's in our neighborhood, and it just baffles me that it isn't included. And the only thing I can think is that maybe because it's not a conventional, like a big box King Soopers or something like that, I'm just not sure why it isn't counted as a full service grocery store. I live in Northeast Park Hill. I use that grocery store. It's the closest one to me, and it's also really affordable. So as we continue to talk about food insecurity in this neighborhood, and I hope we do because it's so important, I just hope we don't discount that business, because it's such an important resource to our community. Park Hill Grocery Store. Thank you.
Thank you, Amy. We have Dr. Lisa Calderon.
Hi, Dr. Ross, thank you so much for the bringing in the subject matter expert. I thought that was an incredibly valuable discussion. So thank you for listening to the input of folks. And, but for being cross-examined by the developer, I think that was a very worthwhile presentation, and agree with Lamone and Evelyn that we need to have one specifically, an easement conversation specifically about Park Hill Golf Course. I'm speaking on behalf of as a resident of District 9, and also now as a member of SOS Denver. When Councilwoman Sedabaka and I met with CPD, we got some commitments, and that include that the platform, the virtual platform, would be available so we could see all participants. It doesn't look like that was honored, so they were going to look into that. We can't tell who is on this call and who isn't. Next, we ask that they re-engage the chat function, at least during certain parts, even if it's intros at the beginning or during public comment. It doesn't look like that was honored. Also, we ask that they consider a way for Councilwoman Sedabaka to give input to panelists, since she has been denied an opportunity to represent her constituents. Living right across the street from Park Hill Golf Course, that still has not been honored. I feel like as a constituent of District 9, I do not have a voice that is representative of me and my interests as someone who uses Park Hill Golf Course as open space. I appreciate that you've moved public comment back to the end of the meeting so we can respond to things that we've heard. I also ask that we share that feedback is shared about the sexism, classism, etc. that I heard on the last call. Black women were disrespected, they were interrupted. No one intervened for them, but they were talked down to by other members of the committee. And so I want to make sure that we're applying rules equally. And then finally, we ask that a Latinx consultant do qualitative analysis using the survey quantitative data, meaning, and the qualitative data related to comments that got overlooked. Again, it is not a best practice, as your survey person said before, to just use statistical surveys. So Dr. Ross, I want to thank you for pointing that out at the last meeting, that qualitative data is valid, and it's actually a very effective way to respond to communities of color. Thank you.
Thank you. Next up, we have Penfield Tate.
Dr. Ross and committee members, thank you for the opportunity to be here with you. Can you hear me?
You are good, and you are on the clock.
Great. I will be brief. I am also a member of SOS. I thought this was a good opportunity for your committee members to be briefed by Mr. Keeter, who clearly is an expert in the field. I would just respectfully offer that since this group is convened for the purpose of discussing or making recommendations or talking about what ought to happen on the Park Hill Golf Course land, it seems reasonable to me that they also ought to be given an opportunity to hear a presentation from me or others with SOS Denver. And I know the developer has had a chance to say a few things, as well as the city, to give you our interpretation of what we think the conservation easement means. And so that way the committee will be informed by hearing Mr. Keeter's sort of high level impression and interpretation, as well as hearing from the two sides involved in the current dispute over how to reuse that space. Secondly, I echo what Ms. Calderon said. We can now see the other folks who have been participating in this call, but I think transparency is important. And I think that we ought to be able to see everyone who's dialed into the call during the call. And I just saw a question come up. SOS stands for Save Open Space Denver. I apologize for using the acronym. Third, to agree with what Amy indicated, I don't know why the Park Hill supermarket gets overlooked constantly, because a number of us use it, and it is BIPOC owned. So I think that is something that also ought to be considered, and the committee ought to be made aware of when you talk about the existence or non-existence of a food desert. Dr. Ross, that's all I have. Thank you for the opportunity to be present and to speak.
Thank you so much. All right, next up, we've got Patrick Gavin.
I do not see him on the attendees list.
Okay.
But I think we have promoted the next Robert Greer.
All right, Robert, welcome. And are you on? Yep, I see you there. You're on mute, sir.
Okay, can everybody hear me?
We will start you now.
All right, thanks everybody. Thanks for the opportunity to comment. I want to say that, as an attorney, I really wasn't convinced by Mr. Keeter's assertions. I know that Mr. Keeter defends easements for a living, but that doesn't mean that every easement serves a worthwhile conservation purpose. I know that conservation easements were abused by Donald Trump to protect his golf courses, and I don't want to see that here. I had asked in the chat whether an easement to protect a NASCAR stadium and that therefore fulfills the element in the statute that it be for recreation, whether that kind of easement would bind future generations forever. Unfortunately, I didn't get an answer. My reading, and I actually have my own copy of the Colorado easement statute because I do eviction defense for a living. There's nothing in the Colorado easement statute that allows the easement parties to ignore the language of the easement. The easement statute does not say that an easement can only be extinguished if it is impossible to fulfill. That's just one way that it can be extinguished. In this case, the easement clearly requires that the parcel be an environmentally destructive golf course in perpetuity, rather than a park or desperately needed housing. I would really hope that anyone who professes to care about the environment or the disadvantaged would help us think of ways that we can avoid being bound by the dead hand of the past to continue in this unsustainability and frankly injustice. Thankfully, I think the law and the language of the easement are clear that there is a path forward. All that said, I would call for the committee to include Candy Sidabaka's office in this process more. The connections between the city and West Side are too strong to eliminate other avenues of community input. And lastly, I just want to give a shout out to Park Hill Supermarket. That's an awesome place. Thank you.
Thank you, Mr. Greer. Thank you to all the community members who joined, and thank you for all of the feedback and information shared with the steering committee. We definitely appreciate that and value your comments. So again, thank you all for being here. Thank you everyone for hanging in with us for a few extra moments. We've just got a couple of quick announcements and then we will get you back into your evening. But we wanted to make sure that your request for the education on the easement and then also on the foods and securities, we wanted to make sure that we had the best amount of time for that. Although I know that there still may be tons of questions, but if you have those, feel free to shoot us an email and we'll get those questions to the speakers that we had here for follow-up if you're interested in that. Our next official meeting is August 17th, 5:30 to 7:30. So please mark your calendars and be on the lookout for the invitation to that. Prior to that, though, there's a couple of things that's happening. The first is the community workshop we talked about at the beginning. That is on August 3rd from 6 to 7:15. We'll make sure that the link is emailed out to you so you can register for that. And if you are interested in engaging with the community folks as a facilitator or volunteering in that process, please reach out to Courtney so she can give you, get you set up to volunteer. Mohammed, yes, I see your question. This information you will get an invitation just like you get for this meeting. And then lastly, you guys received a brief survey from me. I need everyone to finish that as quickly as possible because as we talked about at our last meeting, we'll be doing some small group conversations more specifically on the golf course and getting into that conversation more in depth. And the small group pieces, one of the ways we'll do that, and that survey helps me put us in groups so we can have those conversations and then be able to come back and share the information from those conversations with the larger group. And so the reason why we're doing the small groups is to get some more coordinated and more in-depth conversation, and then we'll come back and share the information from those meetings. So again, thank you guys so much for being here this evening. Again, thank you for your commitment to this work and volunteering your time. You could be so many, when I say small, yes. Yeah, it was just one question. I think there's three options, one question with three options, yes. Takes you about 30 seconds to do. But again, thank you guys for, you could be anywhere doing anything. You could definitely be at your families. And so you're doing this work on behalf of the community. So I appreciate you for being here. And with that being said, have a great evening. And I look forward to talking to you guys all soon. Shanta was sent with the information for today. I don't know. Yep, David, you're good. Imam, are you good?
I
All right.
think he's good. Well, we'll assume he's okay.
We'll assume he's okay, and then we can conclude the recording.
Okay, so I'm going to stop the recording. So do you want to stop cloud recording? If yes. Yep.